This courtroom case starts with what seems like a routine plea deal, but it quickly turns into something far more complicated. A Texas mother of 6 stands before the judge, accused of harassing a public servant after spitting on a police officer. At first, the court appears ready to give her a second chance through deferred adjudication. But as the hearing unfolds, shocking details begin to emerge: drug use during pregnancy, family chaos, and a probation violation that could send her to prison for up to 10 years. The question is, will the judge show mercy, or will this second chance disappear?
Court is calling 2023 CR 8835, State of Texas versus Esther Marie Ariana Diaz. Could I have parties announced for the record for the state?
Daniel S. Clark from the state of Texas.
Defense.
Julie Pollock.
And are you Ms. Diaz?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Is there an application for this case?
Yes, ma'am. Deferred adjudication.
Okay. Ms. Diaz, I'm showing you what's entitled application for deferred adjudication. Did you review that with your attorney? Did you understand it? Did
Yes,
you
ma'am.
sign it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are.
Ms. Diaz, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of harassment of a public servant? That's a third-degree felony.
Yes.
Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe so.
Ms. Diaz, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's a $200 fine to be probated. State recommends deferred adjudication and anger management. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney?
Yes,
Did you
Your Honor.
understand it?
Yes, Your Honor.
Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, ma'am.
Next, I'm showing you outside the agreement. State is requesting that your community supervision be for a term of 2 years. There'll be a TAP evaluation and 50 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State officer exhibit 1 in all attachments.
No objection.
All right, you may continue to confer. Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Yes, ma'am.
At this moment, the judge clearly explains the seriousness of the charge. Harassment of a public servant isn't a minor offense in Texas. It's a third-degree felony, carrying up to 10 years in prison and a possible $10,000 fine. Even though this case may sound like a heated moment during an arrest, legally, it carries very real consequences. Deferred adjudication can be a huge opportunity here because it allows a defendant to avoid a permanent conviction, but only if they successfully complete probation.
All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer its finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Well, we would just ask that you follow the recommendation of the prosecutor in this case.
All right, how old are you?
31.
And who is Carlos Gutierrez?
My older son,
And how old is he?
he's 17.
And are you employed?
Not at the moment.
When's the last time you had employment?
Um, it's been like a year.
How many children do you have?
No, I'm lying. I'm sorry, ma'am. I do Uber and then I DoorDash and I have 5 kids.
All right, and what are your children's ages?
My older son is 17, which is Carlos. My daughter, she's 15. My other son, he's 13. My daughter, she's 11, and my youngest is 4.
And are you currently pregnant?
Yes, ma'am.
This is a critical turning point in the case. Instead of immediately finding the defendant guilty, the judge chooses to defer the adjudication of guilt. In simple terms, that means the court is giving her a chance to prove she can follow the rules. If she completes probation successfully, she may avoid a felony conviction altogether. But there's a catch if she violates probation. The judge can come back later and sentence her to the full prison range.
Who helps you with the children?
My husband.
So that's who has the children right now?
Yes.
All right, so why are you spitting on a police officer?
It was just, I was angry that day because I was looking for my son and I didn't know that he was in a stolo, which is a stolen vehicle. And I was angry. And when I crossed the street, the officer had waved me down, like, stop, like, but I was scared because my son has mental illness. And I was scared that he might make like a wrong move and then they might end up shooting him.
So how did you think spitting on an officer was gonna
Well-
alleviate the situation?
They had jumped on me first, like they both, and I was more angry because I don't know if that time I was still pregnant or if I already had a miscarriage before I got pregnant, this pregnancy. And it kind of, it was just out of like anger, I guess I did it. It's when I was trying to tell them no, what I was trying to do, they still had just one put their like knee in my back and holding my hand. The other was just digging me more in the ground. So it made me mad because I was trying to like stop my son from, but either way, he ended up getting away.
Has child protective services ever been involved in your life?
Once in 2012.
And why were they involved?
Because I had came out dirty with marijuana from secondhand smoke from my daughter,
Which
Right.
daughter?
Ashley.
And how old is she?
She's 11.
So you're saying your 11-year-old was smoking marijuana?
No, I'm not saying that.
Oh, you're saying she was born
Yeah.
testing positive for marijuana?
Yes, ma'am.
Now we finally hear the defendant's explanation for what happened with the police officer. According to her, she was panicking while trying to protect her son, who she says suffers from mental illness. She claims emotions were running high. Fear took over, and the confrontation escalated. But here's the key question viewers should think about: does fear or anger justify assaulting an officer? Courts often look at intent and behavior during the moment hand. Judges tend to have very little tolerance for attacks on law enforcement.
But I did my parenting classes, and then whatever else they needed, I passed it.
All right. And are your parents involved in your life at all?
My mom kind of, but my dad, he's in a hospital in critical condition. Like he passed away, but they revived him. So right now he's still in the hospital.
All right. Is there anything else I need to know about you that I have not asked?
No, ma'am.
All right. This is what the court is going to do. The court is going to sentence you to 3 years deferred adjudication. There's a $200 fine. That will be probated. Anger management, 100 hours of community service restitution. I'm going to order parenting classes.
Yes, ma'am.
When's the last time you used drugs?
Well, I had ended up relapsing when I found out about my dad. It was like 2 weeks ago.
2 weeks. And what did you use?
I used meth.
Okay.
Meth.
You know that's not good to use meth and you're pregnant.
Yes, I know, and that was my biggest mistake, and I'm not doing that no more.
All right, I'm going to order a referral to felony drug court and TAP evaluation. That's going to be in custody. You need to let felony drug court know that you have a drug problem and you need to be in their program. Do you understand?
Yes, ma'am.
And if felony drug court doesn't accept her, follow all TAP recommendations. If TAP recommends inpatient treatment, then she's going into inpatient treatment. There's going to be proof of employment.
The judge now lays out the probation conditions and their extensive 3 years of deferred adjudication, anger management classes, community service, parenting classes, and strict supervision. These requirements aren't random. Courts design probation terms specifically to address the problems they see in the case. In this situation, the judge is clearly focusing on anger control, parenting responsibility, and stability. But what happens next will completely change the direction of this hearing.
Within 30 days of release, there's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors until you're in treatment. There's going to be 90 sober meetings in 90 days. Regular reporting by Zoom or in person. Random regular UAs. Field visits. 1 time per month until further notice. Probation, is there anything else? If she completes parenting classes, the community service hours will be deemed satisfied. But you must complete parenting classes. Do you understand?
Yes, ma'am.
You have a question about anything?
I don't need any treatment like for drugs. Like I could show you that I don't need treatment.
Okay, let me just tell you why I think you need treatment for drugs. And I'm going to ask you some questions, right? And I'm not trying to trap you.
That's
I just
fine.
want to ask you some questions. So when you use meth, did you know you were pregnant?
Yes,
Do you love your unborn child?
yes,
So what you did was you chose drugs over the health of your unborn child. That tells me that you have a drug problem, because otherwise, you know what you would have said? I really want to use, but I'm choosing my baby over drugs. You chose drugs over your child, which says you have a drug problem, or either you don't love your child.
right.
So that's why. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we're going to go off the record. In this court, in order to be successful at probation, communication is key. If you feel like there's an issue you have, let probation know. If you feel like they're not addressing it, you can always come back to the court. Do you understand?
Yeah, okay. Yes, sir.
And it would probably be in your best interest to be in felony drug court. Felony drug court is a hard program, but at least that's somebody that you can pick up the phone and call 24/7 if you're thinking about using. You understand?
Yes, Your Honor.
All right. Do you need anything else from the court?
No, ma'am.
Judge, may
Yes.
I address something?
Yes.
How long does it usually take for drug court to interview them?
Well, because we're at the end of the week, she'll probably be interviewed next week. They're quicker than the TAP evaluation.
I told her she was going to get out today, that you would likely follow the plea bargain. Her father's on life support.
Mhm.
And I
She's,
don't
you know,
how
I'm
much-
sorry, I understand that. But You're not getting out today. I will, if there's no objection from you, counsel, I'll send an email to felony drug court to see if perhaps they can squeeze her in
That would be
sooner than
great.
next week. I'll do that.
That would be great.
Okay. All right, so I'll send that now.
And would you consider lowering the supervisory fees to the minimum?
No, because I've already probated the fine. What are the court costs in this, please? It's a third degree.
This moment shocks the courtroom. The defendant admits she used meth just 2 weeks ago while pregnant. That revelation immediately raises serious concerns for the judge. Substance abuse during pregnancy is not only dangerous for the unborn child, but it also signals a deeper addiction issue. And when judges hear something like this, they often shift from simple punishment to treatment-focused supervision, which is exactly where this case is heading.
And it's harassment of a public servant.
450.
All right. We're back on the record. The court costs in this case are $450. Will you be able to pay that in installments or no?
An installment, yes.
All right, thank you. All right, I'm sending the email now to felony drug courts. Again, be 100% honest with them, and I'm sure they will accept you in their program. And then when you talk to them, and I'm going to put in the email that your father is in the hospital and that you would like to be able to see them, so they'll rush things.
Okay,
Okay.
thank you so much.
All right, you're welcome. I'm sending it right
Thank you,
now.
Judge.
You're welcome.
May we be excused?
Yes. All right, court is calling 2023 CR 8835, State of Texas versus Esther Diaz. Can I have parties announced for the record for the state? Defense?
Joseph Phelps.
And are you Esther Diaz?
Yes, Your Honor.
All right, did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Esther Diaz who was placed on deferred adjudication in 2023 CR 8835 for the offense of harassment of a public servant on February 15, 2024 for a period of 3 years? Is that you?
Yes, ma'am.
Right, stayed?
Yes, Your Honor.
Which allegation are you proceeding on?
Violation condition on or about the 20.
Listen carefully to what the judge says here, because it's one of the most direct moments in the entire hearing. The judge explains that choosing drugs while knowing you're pregnant strongly suggests a serious addiction problem. It's a harsh statement, but it reflects the court's logic. Addiction often overrides judgment. Judges sometimes deliver tough truths like this, not just to punish, but to force defendants to confront the reality of their situation.
28th day of February 2024, in Bear County, Texas, the defendant, Mr. Marie Oriana Diaz, committed the offense of tampering with electronic monitoring device.
How do you plead to that? True or not true?
True.
All right. Are you proceeding on any other allegations?
We haven't been the remaining allegation.
All right, any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There's an agreement in this that we both believe that Ms. Oriana Diaz should have some sort of treatment. We disagree about what that treatment is.
Yes, Your Honor. In other words, the agreement would be to continue her on her deferred alternate amendment conditions for some form of substance abuse treatment. But as Mr. Edelman has indicated, we don't agree on what type of treatment that should be and exactly where. We would leave that to the court, and I would like to address the court with respect to that, Your Honor.
All right, so let's address the tampering with the electronic monitoring device, and then we can address if the court is going to continue Ms. Diaz or not.
Yes, Your Honor. At the time that occurred, at the time that Ms. Diaz had the device on, she was in a, shall we say, very negative relationship with a gentleman who was the father of her now 2-month-old baby. CPS subsequently had gotten involved dealing with that situation, as well as her other 5 children. One of her children had been involved in drugs and it has to do with, I'll give you his name, it's Domingo Herrera, who was a negative influence on the other children as well as Ms. Diaz. She has since gotten away from him. She cut the monitor off because she was dealing with the rather exigent circumstances with her oldest child, who is 16 years old. That child is now in the juvenile system because of some of her drug issues and other issues that were going on. That situation is being resolved. There is a CPS case which is open with Ms. Diaz, which she was following and being involved in with their services prior to.
And here's where things take a dramatic turn. We're now back in court because the defendant violated probation almost immediately. The allegation? She cut off her electronic monitoring device. That's a major violation. When someone is placed on supervised probation with GPS monitoring, removing the device is often treated as an attempt to evade supervision. Legally speaking, that can give the judge the authority to revoke probation entirely and impose prison time.
Coming to court, being in custody now for this, the violation that she's pled true to. Some of the services they were recommending had to deal with relationship counseling, dealing with anger management counseling, as well as substance abuse counseling. With respect to that, she does have 6 children. The 16-year-old, actually, she's not the oldest. The 17-year-old is with her mother, which is the child's grandmother. The 16-year-old is in the juvenile system, being taken care of that way. 3 of the children are with her ex-husband, and then the young 2-month-old child is in foster care right now. Her hope is to try to reunite with the 2-month-old and the other children. It's my understanding, as reported by Ms. Diaz, that CPS, that case is rolling forward, and there's some sort of a proceeding in October of this year that she's trying to meet all the requirements for their purposes. While she has been in custody, which is 110 days, Your Honor, she has completed an anger management class. She has 2 more classes to go to complete her healthy relationships class, and she's been in substance abuse counseling as well, 2 more classes, and she'll get a certificate of completion for that class too. She informs me that Mr. Herrera, she doesn't know where he is, no contact with him, doesn't want anything to do with him. It's her information through CPS that he initially began, but he has not cooperated with CPS. He hasn't done anything. And so their process, quite possibly, I haven't seen the pleadings, but knowing how they work, they may be trying to terminate his parental rights as a part of the CPS program. We're not quite sure. However, from her perspective, she doesn't want anything to do with the man at all.
This is one of the most intense exchanges in the entire hearing. The judge pushes back hard against the defendant's explanation, pointing out that probation officers are not responsible for raising someone's children. The court's message is clear. Personal responsibility matters. Even when life is chaotic, the law still expects probationers to follow the rules. Moments like this show how judges often balance accountability with the possibility of rehabilitation.
Because of the problems that he has caused her and her children.
All right, State, you're requesting what type of treatment?
Safe be, Your Honor.
All right. So I have a few questions. You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Esther Marie Oriana Diaz.
All right, and defense, if ever you want to jump in, feel free to jump in. All right, so what are the ages of your children?
17, 16, 14, 12, 5, and 2 months.
All right, so the 2-month-old is in foster care,
Yes, ma'am. Yes, Your Honor.
and the 5-year-old is with your ex,
Yes.
and that is not Mr. Herrera.
No,
And the 12-year-old is,
my ex-husband as
14?
well.
and the 16-year-old,
She's in juvie.
and the 17-year-old with the grandmother.
Yes.
All right, so the 16-year-old, why is the 16-year-old in juvenile custody?
She kept running. My mom was having problems with her.
And so she was with your grandmother.
Yes.
All right. Oh, I don't want to go into great detail. I'm just trying to figure things out.
Yes, ma'am. Yes, ma'am.
So now here's my question in defense. If you want to jump in, feel free to jump in. I don't understand how cutting off the monitor has anything to do with anything. I mean, it's not as though Mr. Herrera was monitoring her. It's not like if she's on GPS, he's monitoring her so he knows where she is. It's probation that was monitoring her.
It had to
Yes.
do with,
I'm sorry, go ahead.
it had to do with the fact that she was previously ordered to complete Alpha Home. And she couldn't do that with the monitor on. And that delves into, and it is intertwined with Mr. Herrera and the relationship that she had with him. And so she did not complete Alpha Home. She in essence left Alpha Home after 1 week.
Okay, so she was in Alpha Home on GPS
Yes, Your Honor.
and she cut the GPS monitor off.
Yes, Your Honor.
Yes.
Sorry to cut. It wasn't necessarily that way. He misunderstood. What I meant was my daughter was giving my mom problems. It wasn't necessary because my ex-boyfriend. It was because my daughter, nobody can handle them. And they only listen when I'm there. And so I had to cut my monitor to go get my daughter.
No, you didn't have to cut your monitor
Why-
off. You could have called probation and said,
I called them, my mom called them, they didn't want to do nothing. They didn't, my son's probation officer is the same probation officer for my daughter. They didn't even go look for her. Little did they know my son was even doing the other things. I had to be the one keep calling and calling, and they weren't doing their job. Secondly, my daughter was going to the Westway apartments where there's a bridge, where there's a lot of homeless people.
all right, so here's the thing. I understand what you're saying about probation not doing their job, but honestly, you were not doing your job as a parent because that's why probation is in their life. And the government, honestly, even when people are juveniles, it's really not the probation's officer job to raise your children. That's your job. And the fact that your child ran away still doesn't excuse your thinking, which is, I'm going to cut off my monitor because my child ran away and my child will only listen to me. If your child will only listen to you, why are your children living with the grandmother instead of you?
Exactly. I was just trying to take my daughter back to my mom's and let her, turn herself in, do it the right way, so I can turn myself in, so I can be at peace and know that she's okay. While I'm doing my, doing what I have to do as a parent.
Well, let me just tell everybody, one, I don't even think she should be continued on probation. I think she should be revoked. But what I can tell you is, I am not going to do the treatment that you want. It's going to be safety.
Okay, it's fine.
So, well, no, you need to listen.
Yes,
So even if I consider continuing you, it's going to be safety. So everything else is off the table. Any questions?
Not from the state, Your Honor.
Any questions?
Not from the defense, Your Honor.
All right, probation, what are you requesting? Okay. So probation wants to continue her?
Yes.
Okay. All right, this is what the court is going to do. I'll deny the motion. Alternate amend conditions to extend for 2 years. We can do a referral back to felony drug court. And if not accepted, then safety.
Judge, I would like to point out that referral was just not to as a whole.
All right.
If I'm saying the ADA opposed it, and that's why she wasn't granted, or she wasn't accepted to drug court. Otherwise, she met the requirements for it.
Who's the ADA?
It doesn't even give you that information. Judge, it does say that she met the criteria. That's all I have.
And I have counseled Ms. Diaz on how stringent and how difficult drug court is to complete. And she has informed me that she is ready, willing, and able to do whatever she needs to do.
All right, just one moment. All right, so here's my other question. Has anyone looked into if she has a CPS case, CPS has a treatment court there as well. Has anyone checked to see if they will accept her?
I have not, Your Honor.
All right. Yes,
I have a outpatient visit with the CPS worker on the 3rd. And she was telling me that if they didn't have classes for me here, that they would provide the classes for me there.
all right. So what's gonna end, I can tell everybody what's gonna end up happening, right? And y'all tell me if you all want to continue down this road of sending her to safety. In CPS cases, you only have a year. Council, as you know, to get your act together for them to consider placing your children with you. Sometimes they will extend it, maybe extend it for 3 months. Most I've seen is 6 months, and that's it. So if you're not accepted into felony drug court, it's going to be very difficult for you when you're sent to safety. So I'm going to ask that she be re-referred to felony drug court, and maybe your attorney can speak to them at felony drug court and talk to the ADA and see if they're willing to reconsider. But if you're not accepted in felony drug court, you're going to go to safety.
Yes, Your Honor.
So there's a referral to felony drug court in custody. If not accepted, then safety. Is there anything else from either side?
Nothing from the defense, Your Honor.
Okay, and just one moment. Yeah, okay. All right, good luck to you.
Thank
Oh,
you.
and I'm sorry, one more thing on the record probation. She'll receive credit for the anger management course.
I'm sorry, I received my other 2 certificates in 2 weeks.
All right, sure.
It should
Just,
be in the system, they said.
all right, just let probation know.
Yes,
All right, thank you.
thank you.
In the end, the judge chooses not to revoke probation entirely, but the second chance comes with strict conditions. The court orders another referral to felony drug court, a demanding rehabilitation program designed for serious substance abuse cases. If the defendant succeeds there, she may still turn her life around and reunite with her children. But if she fails again, the consequences could be far more severe. Cases like this remind us how the justice system often walks a fine line between punishment and rehabilitation. If you found this courtroom breakdown as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom cases and legal breakdowns.